trust is and how it works. A trust is a legal arrangement where one party, known as the grantor, transfers assets to another party, called the trustee. The trustee holds and manages these assets for the benefit of a third party, known as the beneficiary. There are several types of trusts, each serving different purposes. The most common types are revocable trusts and irrevocable trusts. A revocable trust can be altered or revoked by the grantor during their lifetime. This flexibility allows you to make changes as your circumstances or intentions evolve, making it an excellent choice for those who want to retain control over their assets. An irrevocable trust, on the other hand, cannot be easily changed once it is established. This type of trust can provide significant tax advantages and protect assets from creditors, making it ideal for those looking to secure their wealth for future generations. Special purpose trusts are designed for specific goals. Let's look at some common examples. A charitable trust can help you support a cause you care about while potentially offering tax benefits. A special needs trust can provide for a loved one with disabilities without jeopardizing their eligibility for government benefits. A spendthrift trust is useful for protecting a beneficiary who may not be financially responsible. A Medicaid Asset Protection Trust helps individuals qualify for Medicaid while protecting their assets. A testamentary trust is established through a will and goes into effect upon the grantor's death. An asset protection trust is designed to protect your assets from creditors. Creating a trust involves drafting a legal document that outlines the terms of the trust and appointing a trustee. Once established, the grantor transfers assets into the trust, which the trustee then manages according to the trust's terms. The trustee has a fiduciary duty to act in the best interests of the beneficiaries, ensuring the assets are managed and distributed as specified in the trust document. Using a trust offers several benefits. It can help avoid the lengthy and public probate process, ensuring a quicker and more private transfer of assets. Trusts also provide greater control over how and when assets are distributed, which can be particularly useful for beneficiaries who are minors or have specific needs. Additionally, certain types of trusts may offer tax advantages, potentially reducing the overall tax burden on the estate. In summary, trusts are versatile legal tools that can provide significant benefits in estate planning.
Welcome back to our series on estate planning for business owners. In our last video, we discussed what business succession planning is and why it's crucial. Today, we're going to walk you through the steps for creating a robust business succession plan. Step 1. Identify potential successors. Start by evaluating who could take over your business. This could be a family member, a key employee, a business partner, or an outside buyer. Consider their skills, experience, and commitment to the business. It's essential to choose someone who can maintain and grow the business successfully. Step 2. Define your goals and vision for the future. Think about what you want to achieve with your succession plan. Do you want to keep the business in the family, sell it for the highest value, or ensure a smooth transition to a trusted employee? Clearly outlining your goals will help guide the planning process. Step 3. Develop a formal succession plan. This plan should include legal documents and agreements that outline how the transfer of ownership and management will occur. A key document in this process is the buy-sell agreement. This agreement specifies how a partner's share of the business may be reassigned if that partner dies or leaves the business, detailing the conditions under which the transfer will take place. Step 4. Conduct a business valuation. Understanding the value of your business is crucial for the succession plan. A professional valuation will provide an accurate picture of what your business is worth, which is essential for buy-sell agreements, estate planning, and setting a fair price if the business is sold to an outside party. Step 5. Plan for funding the succession. Determine how the successor will finance the purchase of the business, if applicable. Options include installment sales, loans, or using life insurance policies. For instance, a life insurance-funded buy-sell agreement can provide the necessary liquidity to buy out a deceased owner's share of the business without straining the company's finances. Step 6. Prepare your successor. Start training and mentoring your chosen successor well in advance of your planned transition. This ensures they have the knowledge, skills, and experience to lead the business. Gradually increasing their responsibilities can help them gain confidence and be better prepared for the leadership role. Step 7. Communicate the plan. Share your succession plan with key stakeholders, including family members, employees, business partners, and advisors. Clear communication helps prevent misunderstandings and conflicts, ensuring everyone understands and supports the plan. Step 8. Review and update the plan regularly. Business and personal circumstances can change, so it's important to review and update your succession plan periodically. This ensures the plan remains relevant and effective in achieving your goals. Creating a business succession plan is a complex but essential task for ensuring the longevity and success of your business. By following these steps, you can create a comprehensive plan that provides a smooth transition of ownership and management, protects your business's value, and achieves your personal and financial goals. Thank you for watching. If you have any questions or need personalized advice, consult with a qualified estate planning attorney. See you in the next video.
Welcome to our comprehensive guide on estate planning. This presentation aims to provide you with essential knowledge to ensure peace of mind for you and your loved ones. Let's explore the key aspects of estate planning and how it can benefit you. Estate planning involves arranging for the management and disposal of your estate after death or incapacitation. It ensures your wishes are followed and helps minimize taxes, legal fees, and family disputes. Let's delve into why this process is crucial. Estate planning is vital as it protects your loved ones and assets. It helps avoid probate, designates guardians for minor children, and ensures healthcare decisions align with your values. Understanding these benefits is key to effective planning. An estate plan comprises several key components: a will, trusts, power of attorney, healthcare directives, beneficiary designations, and a letter of intent. Each plays a crucial role in ensuring your wishes are respected and executed properly. A will is a legal document specifying asset distribution. It appoints an executor and names guardians for children. However, it must go through probate, which can be time-consuming and costly. Understanding its role is essential in estate planning. Trusts help avoid probate and provide more control over asset distribution. They come in various types, including revocable, irrevocable, special needs, and charitable trusts. Each serves different purposes and offers unique benefits. A power of attorney, POA, appoints someone to handle financial and legal matters if you're incapacitated. A durable POA remains in effect after incapacity, ensuring your affairs are managed according to your wishes. Healthcare directives include a living will, which outlines end-of-life care preferences, and a healthcare proxy, which appoints someone to make medical decisions on your behalf. These documents ensure your healthcare wishes are respected. Beneficiary designations apply to life insurance, retirement accounts, and some bank accounts. They supersede your will, so it's crucial to keep them updated to reflect your current wishes and avoid unintended consequences. Estate taxes can significantly impact your estate's value. The federal estate tax threshold is $13.61 million as of 2025, but this is subject to change. Some states have their own taxes. Using trusts and gifting strategies can reduce tax liability. Avoid common estate planning mistakes: not having a plan, forgetting to update documents, ignoring digital assets, not considering long-term care, and choosing the wrong executor or trustee. Awareness of these pitfalls is crucial. Creating an estate plan involves several steps: taking inventory of assets and debts, identifying goals and priorities, choosing beneficiaries, drafting legal documents, and reviewing regularly. Each step is vital for a comprehensive plan. Update your estate plan during major life events: marriage, divorce, birth or adoption of a child, major asset changes, death of a family member, or changes in tax laws. Regular updates ensure your plan remains relevant and effective. Working with professionals can enhance your estate planning process. Consider consulting an estate planning attorney, financial advisor, tax professional, and trust officer. Their expertise can provide valuable insights and guidance. Final thoughts. Estate planning is not just for the wealthy. Start early and review regularly to protect what matters most, your people and your wishes. A well-crafted plan ensures peace of mind for you and your loved ones. We now open the floor for questions. For further assistance, please contact the Heritage Law Office. We're here to help you navigate the complexities of estate planning and ensure your wishes are honored.
Before your student leaves for college, there is one thing most families forget. Not bedding, not textbooks, not a laptop, legal paperwork. Because the moment your child turns 18, the law sees them as an adult, and that changes everything. As a parent, you may still be paying tuition. You may still be covering health insurance. You may still be the first person they call when something goes wrong. But legally, you may no longer have automatic access to their grades, their student account, their medical updates, or even the ability to help in an emergency. So today, we're going through the essential legal documents every college student should consider before leaving for university. This video is for educational purposes only and is not legal advice. Forms and requirements vary by state, so speak with a qualified attorney or check your state and university requirements before signing anything. Here's the privacy gap most families do not see coming. When a student turns 18, parents do not automatically have the same legal access they had when that student was a minor. That means if your student is struggling academically, you may not be able to simply call the school and ask for grades or records. And the same kind of issue can come up with health information. Imagine your student is away at school and has a medical emergency. They are taken to the hospital. You call the hospital, terrified, asking what happened, what their condition is, and what decisions need to be made. But without the right authorization, the hospital may be limited in what it can tell you. That does not mean doctors are trying to be difficult. It means privacy laws apply because your student is now a legal adult, and verbal permission may not be enough, especially during a crisis when your student is unconscious, sedated, overwhelmed, or unable to clearly communicate. That is why these documents matter before move-in day. The first document to ask about is a FERPA release, or student records authorization. This is usually handled through the college or university. It allows the student to give a parent or trusted person permission to access certain education records. This may include grades, billing information, financial aid details, disciplinary records, or other student account information, depending on what the school allows and what the student authorizes. This is important because even if a parent is paying the bill, the school may still require the student's consent before sharing protected education records. So before classes begin, have your student log into their university portal and search for terms like FERPA release, parent access, authorized user, or student records consent. This is not about spying. It is about making sure the family can help when help is actually needed. Now let's talk about medical documents. The first medical document is a HIPAA release form. HIPAA is the federal privacy law that protects health information. A HIPAA release allows your student to name who can receive medical updates. This is the baseline document for communication. It does not necessarily give a parent the power to make medical decisions. It simply helps doctors, hospitals, or other medical providers share information with the people the student has authorized. So if your student wants a parent, guardian, sibling, or trusted family member to be kept in the loop, the HIPAA release is the starting point. The second medical document is a healthcare proxy, medical power of attorney, or advanced healthcare directive. The name depends on the state. This document allows the student to choose someone to make medical decisions if they cannot make those decisions themselves. That is the key phrase. If they cannot make decisions themselves. This is not about taking control away from the student. It is about having a trusted person legally ready to step in if the student is unconscious, incapacitated, or otherwise unable to speak for themselves. And here is the practical tip many families miss. Do not leave these forms sitting in a drawer at home. Keep digital copies on the student's phone. Keep copies in a secure cloud folder. Make sure the parent or trusted person also has access. In an emergency, the best document is the one you can actually find. Next is a durable power of attorney, sometimes called a financial power of attorney. This document allows the student to appoint someone to handle certain financial or legal matters if needed. That could include dealing with tuition issues, bank problems, apartment leases, insurance paperwork, car registration, or time-sensitive documents that require a signature while the student is away. Think about real life. A lease needs to be signed by Friday. A bank account gets locked. Financial aid needs a document corrected. A tuition payment issue pops up while the student is in class, traveling, sick, or unavailable. Without proper authorization, parents may be stuck on the outside, unable to help quickly. A durable power of attorney can create a safety net, but this is also where families should be thoughtful. The document can be written broadly or narrowly. It can be designed to give power only in specific circumstances. It can limit what the appointed person can do. So the goal is not to take away the student's independence. The goal is continuity. The student remains the adult. The student remains in charge. The paperwork simply creates a backup plan. Now let's turn this into a simple checklist. Before move-in day, consider having these documents completed: a FERPA authorization through the university, a HIPAA release form, a healthcare proxy or medical power of attorney, a durable financial power of attorney, and any state-specific forms recommended by an attorney. For storage, keep the physical originals in a safe place at home, such as a fireproof document box. The student should also have digital copies saved securely on their phone. The family should create an encrypted shared folder with copies of the signed documents, emergency contacts, insurance cards, the student ID number, the university health center information, and the contact details for the student's doctor. Make sure the folder is secure. Use strong passwords. Turn on two-factor authentication. Do not just email sensitive documents back and forth casually. And set a real deadline. Not sometime before school starts. Make the deadline move-in day. Actually, make it 1 week before move-in day, because some documents may need signatures, witnesses, or notarization depending on your state. Sending a student to college is a major milestone. It is exciting, it is emotional, and yes, it comes with a lot of logistics. But these legal documents are not about expecting something bad to happen. They are about being prepared. They give students independence while giving families a safe, legal way to help if something goes wrong. With the right paperwork in place, everyone can breathe a little easier. Your student can focus on classes, friendships, and becoming an adult. And you can have peace of mind knowing that if there is an emergency, you are not stuck on the other side of a privacy wall. Before they pack the car, pack the paperwork. It may be one of the most important things they bring to campus.
The same way that an LLC or a corporation is a different entity from its shareholders. A trust is a different legal entity from the trust creator. Trusts are capable of acting independently, owning assets independently, filing lawsuits, and being sued themselves. It is because of these functions that we need to be cautious when it comes to transferring qualified assets, such as an IRA or 401k, to a revocable trust. The transfer of an IRA or 401k to a trust is similar to transferring it to a different owner, such as a different person, a different corporation, a different entity, and in doing so, the IRS considers this a taxable distribution. Similar to qualified assets, when a health savings account and medical savings account are transferred to a trust, they may be subject to taxes. Additionally, transferring a vehicle to a trust may result in the need to pay title transfer fees and additional taxes for issuing the new title. This list is not exhaustive. Other than the above-mentioned items, a revocable living trust may be a good option for the majority of your assets. This means your bank account, your house, your post-tax investment account, etc., should likely be transferred to a trust. You should pay special attention to retitling your assets to a trust to avoid unwanted taxes or other consequences. Contact one of our attorneys to make sure your assets are properly protected.
Here's a number that surprises most people. Roughly 2 out of 3 Americans die without a will. They don't intend to, they just never get around to it, and then it's too late. And when that happens, the state steps in and decides who gets everything you built. Not you. Not your family, the state. What I'm about to walk you through is what actually happens to your home, your savings, and your kids if you die without a will. It's not what most people expect. And once you hear it, you'll understand why this is the most important paperwork you'll ever sign. So let's start with the basic question. If you die without a will, what happens to your stuff? Here's the honest answer. Your stuff doesn't just disappear, it goes to court. A process called probate. The state appoints someone to take an inventory of everything you own, pay your debts and taxes, and then distribute what's left. But here's the catch. The state isn't distributing your assets according to what you would have wanted. It's distributing them according to a rigid, one-size-fits-all formula called the laws of intestacy, which literally means dying without a will. And that formula often does not match what a real family would choose. Your stepchildren, your close friends, the charities you cared about, your long-term partner if you never married, under this formula, they may get nothing at all. Let's make this concrete, because this is where it gets personal. Say you own a home and have a life insurance payout sitting in savings, and you pass without a will. If you're married, your spouse doesn't automatically get everything. In many states, they get a share, and the rest is carved up among your children. If you have kids from a previous marriage, the state may divide your home between your new spouse and those children, creating a situation where your spouse must either buy out your kids, sell the family home, or share it with people they may not get along with. If you're unmarried but living with a partner, a very common situation, your partner inherits nothing unless the property is titled in both names. The entire estate may go to blood relatives you haven't spoken to in years. And if you have no relatives at all, the state can claim your entire estate. Everything you worked for goes to the government. Here's the part that keeps estate attorneys up at night, and it's the reason this video exists. If you die without a will and you have minor children, you have not named a guardian. That decision, who raises your kids if you're gone, does not get made by you. It gets made by a judge. The judge will consider family members, and sometimes the state will place your children with someone you would never have chosen. Your child's future is decided by a stranger in a courtroom, based on a formula, not on your wishes. You named a guardian in your mind 1,000 times, maybe your sister, maybe your best friend. But in your mind is not a legal document. If it's not written down, it doesn't exist. This is the single most important reason to have a will. Not for your money, for your children. A will is the only document that lets you choose who raises them. So by now you might be thinking, fine, I'll get a will. And you should. But here's the honest truth. A will is the foundation, not the whole house. A will does 3 essential things. It names your executor, it names a guardian for your kids, and it says who gets your assets. It's one of the most important documents you'll ever sign. But it does not automatically protect your home from nursing home costs. It does not automatically avoid probate. And it does not handle the 3 biggest threats to everything you've built. That's what this series is about. Over the next few videos, I'm going to show you the specific legal tools that protect your home and savings from the 3 things that drain family estates: nursing home costs, probate fees, and family conflict. You're watching video 1, the foundation. Get the will right, and the rest of the structure has somewhere to stand. Here's the thing I need you to hear, and I'll say it plainly. The best time to do this was years ago. The second best time is this week. I know it feels like a task for someday, but I've seen too many families learn the hard way that someday doesn't wait. The health crisis that lands you in a nursing home doesn't check your to-do list first. It doesn't wait until you've drafted your documents. It arrives on its own schedule, and if your plan isn't in place, it's too late for the tools that require planning in advance. That's the uncomfortable truth about estate planning. The most powerful protections, the ones that shield your home from the nursing home, the ones that keep your savings out of probate, have to be set up while you're healthy. Not in the middle of a crisis, before. So here's what I want you to take away. Without a will, the state decides who gets your home, your savings, and your kids. 2 out of 3 Americans never write one, and their families pay the price in court fees, conflict, and lost control. But a will is just the foundation. The real protection for your home and your life savings comes from the tools I'm going to show you next. If you want to make sure your family is protected, the first step is a conversation. Reach out to an attorney. Subscribe and turn on notifications so you don't miss the next video.
Understanding special needs trusts. In this video, we will explain what a special needs trust is, its benefits, types, key considerations, and common mistakes to avoid. A special needs trust, or S&T, is a legal arrangement designed to manage assets for the benefit of a person with disabilities without disqualifying them from government benefits, such as Medicaid or Supplemental Security Income, known as SSI. The primary objective is to enhance the quality of life for the individual by providing financial support for needs not covered by government programs. Special needs trusts offer numerous benefits. They ensure that the beneficiary continues to qualify for essential government benefits, provide a steady source of funds for additional care, safeguard the beneficiary's assets from creditors, allow professional management of funds, and offer peace of mind to families. There are 3 main types of special needs trusts: First-party special needs trusts are funded with the beneficiary's own assets, such as an inheritance or a personal injury settlement. Third-party special needs trusts are funded by someone other than the beneficiary, typically parents or grandparents. Pooled special needs trusts are managed by nonprofit organizations and pool resources from multiple beneficiaries for investment purposes, while maintaining individual accounts for each beneficiary. When creating a special needs trust, there are several key considerations. Selecting the right trustee is crucial. They must be knowledgeable about public benefit programs and capable of managing the trust assets effectively. Funding the trust properly is also essential, with common sources including gifts, inheritances, life insurance policies, and personal injury settlements. The trust document must be carefully drafted to comply with legal requirements and protect the beneficiary's eligibility for government benefits. Regularly reviewing and updating the trust ensures it continues to meet the beneficiary's needs and complies with current laws. Avoiding common mistakes is important in maintaining the effectiveness of a special needs trust. Ensure the trust is adequately funded to cover long-term needs. Choose a trustee with the necessary expertise and commitment. Properly structure the trust to preserve government benefit eligibility and regularly update the trust to align with the beneficiary's evolving needs and changes in the law. Setting up a special needs trust is a compassionate and prudent step in securing the future for someone you care about. It provides financial security and enhances the quality of life for individuals with disabilities. How to save over $100,000 through Medicaid planning. Nursing home costs are expensive and add up quickly. Within a short period of time, an entire life savings can be depleted by paying for the cost of a stay in a nursing home. With proper planning, however, substantial value may be able to be preserved and passed along. Here is an example of how to save over $100,000 through active Medicaid planning. Mary has a savings account worth $75,000 and an investment account worth $150,000, totaling $225,000. Mary will be requiring nursing home care starting next month. Nursing home expenses are $10,000 per month. Since Mary did not previously buy long-term care insurance or pre-plan, Mary will have to cover the costs out of pocket. Mary will have to pay out of the savings account and liquidate the investment account to pay for nursing care. In less than 2 years, Mary will be completely out of money. Medicaid is administered by states according to federal requirements. State rules may vary. For example, in Wisconsin, the Medicaid rules are structured so that once you have less than $2,000 in assets, Medicaid will pay for a required nursing home stay. Now that Mary has spent $225,000 and is out of money, public benefits will pay for Mary's nursing home care. Most people struggle with the concept of seeing their entire life savings depleted very quickly. They would prefer to transfer those assets to their children, family members, friends, or donate that money to charity, rather than seeing the money depleted. The easy solution seems to be to give away all your assets to drop below the asset limit and qualify for Medicaid. It is not that easy. Medicaid will not allow you to gift away all your assets and immediately qualify for Medicaid benefits. When gifting assets, Medicaid imposes a divestment penalty, causing an ineligibility period for Medicaid, time that must pass before public benefits will pay for nursing home expenses. The larger the value of the gift made, the longer the ineligibility period. The ineligibility period only starts counting down when you apply for Medicaid, and you would be otherwise eligible if the ineligibility period did not exist. At the time of this video, in Wisconsin, for every $303.38 given away, 1 day of Medicaid ineligibility is assessed. If Mary were to give away all her money, then apply for Medicaid, she would be ineligible for 2 years after applying and must find funds to pay for nursing home expenses. Here's one possible way to solve this issue. Again, there are different rules in different states, so be sure you talk to a professional. Mary has a total of $225,000. Mary splits the money into two different pieces. One that Mary keeps and turns into a stream of income, and one that Mary gives away to her family, friends, or charity. In this example, Mary converts $118,000 to a stream of monthly income. Income is treated differently than assets and do not count towards the Medicaid asset limit in Wisconsin. Mary receives the money back in equal payments over 12 months as income. We will discuss what Mary does with this cash flow in just a bit. Mary also gives away the remaining $107,000, either to individuals or to a special type of trust, an irrevocable trust. We believe an irrevocable trust is generally a better option for numerous reasons, which we will discuss in a separate video. At this point, Mary has no money remaining. She has gifted $107,000 to family, friends, or a trust, and has spent $118,000 to acquire a monthly income stream. Giving away money is considered a gift, causing a divestment period where Mary is ineligible for Medicaid benefits for a period of time. In Mary's scenario, a gift of $107,000 will cause an ineligibility period of 352 days. Now that Mary has less than $2,000, Mary can apply for Medicaid. Mary will be assessed an ineligibility period due to the $107,000 gift. However, the ineligibility period will now start counting down, and Mary will be eligible for coverage at the end of the 352-day ineligibility period. During the ineligibility period, Mary will use the monthly income stream to pay the nursing home expenses. That stream of income will expire the same time as Mary's ineligibility period, leaving Mary with less than $2,000 during the ineligibility period and when the ineligibility period ends. At the end of the ineligibility period, the income stream will stop, and Medicaid will cover Mary's nursing home expenses. Meanwhile, the assets that are set aside in the trust or gifted to individuals are saved. They are not subject to being spent on nursing home expenses. Rather than spending $225,000 on nursing home expenses and having the entire value of the assets depleted, $107,000 were able to be passed on to friends, family, or charity. Our next video will be about how Mary could have saved almost all of the $225,000 with proper Medicaid pre-planning. Medicaid planning and Medicaid applications are complicated, precise, and vary state to state. One mistake can be very costly. Contact one of our attorneys to make sure your assets are properly protected.
I'm healthy, I eat kale, so I don't need estate planning, right? Wrong. You need a power of attorney. Yesterday. If you get in an accident or end up in the hospital and can't speak for yourself, no one can legally help you. Not your partner, not your mom, not your best friend. Without a power of attorney, they might not even be allowed to talk to your doctor. Imagine this. You're unconscious, your bills are due, your pet needs food, your life is on hold. But with a power of attorney, your person can pay your bills, talk to your doctors, and keep things moving. Without it, they might have to go to court just to help you. And that takes time, money, and a whole lot of stress. So listen, you don't need to be old. You need to be prepared. Power of attorney. Get it, sign it, store it, because adulting means protecting your future.
In this video, we will explore how trusts play a crucial role in business succession planning. If you're looking to ensure the smooth transfer of your business to the next generation, stay tuned. Business succession planning is essential for the longevity and stability of a business. Trusts are a powerful tool in this process, helping manage and transfer business assets effectively. So, what exactly is a trust? A trust is a legal arrangement where one party, known as the trustee, holds and manages assets for the benefit of another party, the beneficiary. Trusts can provide several advantages in business succession, such as maintaining control over assets, offering tax efficiency, protecting against creditors, and ensuring continuity and stability. There are various types of trusts used in business succession planning. Let's briefly discuss some of the most common ones. Revocable trusts allow the business owner to retain control over the trust assets during their lifetime and make changes as needed. This type of trust can avoid probate, ensuring a smooth transition of assets to the beneficiaries upon the owner's death. Irrevocable trusts, on the other hand, cannot be modified or revoked once established. These trusts provide significant tax benefits by removing assets from the owner's taxable estate and offering protection against creditors and lawsuits. Testamentary trusts are created through a will and become effective upon the owner's death. They allow detailed instructions for asset management after death but require probate before becoming effective. Charitable trusts are designed to benefit a charitable organization while providing tax benefits to the business owner. These trusts can ensure that a portion of the business assets supports charitable causes. Using trusts in business succession planning offers several strategic benefits. Trusts can help avoid the lengthy and costly probate process, maintain confidentiality, ensure business continuity, provide flexibility in asset distribution, minimize family disputes, and protect beneficiaries. To implement a trust in your business succession plan, follow these steps. First, assess your business and personal goals. Determine your objectives for the succession plan and identify key individuals involved in your business. Next, consult with an experienced attorney to explore your options and create a tailored plan. Choosing the right type of trust is crucial, as it should align with your goals and provide the desired benefits. Draft the trust document, clearly outlining the terms and conditions, as well as the roles and responsibilities of the trustee and beneficiaries. Then, fund the trust by transferring ownership of the business assets into it. Communicate the plan to key stakeholders, including family members and business partners, to ensure a smooth transition. Regularly review and update the trust to reflect changes in business or personal circumstances. Consider the example of a family-owned manufacturing business. The owner, nearing retirement, established a revocable trust to transfer ownership to their children. The trust included specific instructions on management roles and profit distribution. By doing so, the owner ensured a clear management structure, tax efficiency, and continued business growth under the new management. In summary, incorporating trusts into your business succession plan can provide numerous benefits, including control, tax efficiency, and asset protection. To secure the future of your business, consult with a professional attorney and develop a well-structured trust plan today. Thank you for watching. If you found this video helpful, please like and subscribe for more content on business succession planning.
Estate planning sounds like paperwork for later, but it's actually a toolkit for protecting your people and your peace, right now. In the next few minutes, you'll see the hidden benefits most people miss, plus a simple action plan to get started. Estate planning gets framed as something you do when you're older, but the real value shows up whenever life gets messy. Moves, kids, blended families, businesses, illness, even online accounts. Think of this as clarity planning. Fewer surprises, fewer delays, less stress. One of the biggest hidden benefits is emotional. Fewer family blow-ups. When plans are unclear, people fill the gaps with assumptions, and grief amplifies everything. A good plan spells out decisions, roles, and timing, so your loved ones aren't negotiating under stress. Another benefit people rarely talk about: privacy. In many places, once probate is filed, a will can become part of the public record. With trust-based planning and good beneficiary setup, you can often keep sensitive details, like who gets what and when, out of the spotlight. Speed matters. Probate timelines vary, but it's common for the process to take many months. When key assets are set up with beneficiary designations, transfer on death options, or properly funded trusts, your family may be able to access resources sooner, often with fewer fees and fewer court steps. Here's the part most people miss. Estate planning is also incapacity planning. If you can't speak or sign, who pays bills, manages accounts, and makes health decisions? A power of attorney and advanced healthcare directives help your family act with confidence without guessing. If you have kids or people who rely on you, this is huge. Estate planning can name guardians, set backups, and create a structure for managing funds responsibly. It's one of the few ways to turn "I hope" into "I decided." If you own a business, estate planning isn't optional. It's continuity planning. The plan can define who has authority, how partners are bought out, and what happens if you're unavailable. Done well, it protects employees, customers, and the people who depend on that income. Your estate isn't just your house and accounts. It's also your digital life, passwords, photos, subscriptions, even crypto or online businesses. A plan can name who handles digital assets and where your instructions live, so accounts aren't lost or locked forever. Estate planning can be values planning. Beyond dollars, you can support causes, tell family stories, and create guardrails that reflect what you cared about. Even a simple letter, kept with your plan, can reduce misunderstandings and help your family honor your intentions. To get value fast, start small. First, make an inventory of major assets and accounts. Second, choose the people, who decides and who backs them up. Third, take one next step and book an appointment, bringing your list. And a quick note: this is educational, not legal advice. Rules vary, so work with a qualified professional for your situation.
In this video, we will discuss how to amend a living trust, including the reasons for making amendments and the steps involved in the process. A living trust, also known as a revocable trust, is a legal document created during a person's lifetime that designates a trustee to manage the individual's assets for the benefit of the beneficiaries. One of the main advantages of a living trust is that it allows for the easy transfer of assets without the need for probate. There are several common reasons why you might need to amend a living trust. You may need to add or remove beneficiaries due to marriage, birth of children, or death. You might want to appoint a new trustee or successor trustee. Perhaps you need to modify how the assets are distributed among beneficiaries. Or you could be adding newly acquired assets to the trust. Changes in personal circumstances, such as marital status, financial status, or health conditions, can also necessitate amendments. To amend a living trust, follow these steps. First, review your original living trust document to understand its provisions and identify the sections that need changes. Next, decide on the type of amendment. There are two primary methods: a trust amendment for minor changes or a restatement of the entire trust for major changes or multiple amendments. Then, draft the amendment. Clearly title the document as an amendment to the living trust, specify the date of the original trust and the date of the amendment, detail the specific changes being made, and include a clause reaffirming the unchanged portions of the trust. Sign and notarize the amendment. Both the grantor and the trustee, if different from the grantor, should sign the document in the presence of a notary public. Attach the amendment to the original trust document to ensure all parts are easily accessible and legally recognized. Finally, notify all relevant parties, including trustees, beneficiaries, and financial institutions, of the changes to the trust. When amending a living trust, it's important to maintain consistency in the document to avoid any confusion and potential legal disputes. Consider how the amendment might affect your estate taxes and consult with a tax advisor if necessary. If you amend your living trust, you may also need to update related estate planning documents, such as wills, powers of attorney, and beneficiary designations. When changing successor trustees, choose someone you trust to manage your assets responsibly. In summary, amending a living trust involves reviewing the document, deciding on the type of amendment, drafting the changes, signing and notarizing, attaching the amendment to the original trust, and notifying relevant parties. While it's possible to amend a living trust on your own, consulting with an experienced attorney is highly recommended to ensure that the amendments are legally valid and correctly executed. An attorney can provide guidance tailored to your specific situation and help avoid common pitfalls. Medicaid provides health coverage to millions of Americans, including eligible low-income adults, children, pregnant women, elderly adults, and people with disabilities. Medicaid is administered by states according to federal requirements. The program is funded jointly by states and the federal government. The Medicaid system will pay for your care costs, including a stay in a nursing home if you meet certain qualifications. The Medicaid system has an asset limit. As of the day this video was produced, as an unmarried person in Wisconsin, you must have less than $2,000 in assets to qualify for Medicaid. If you have more than $2,000 of assets, you must first spend your assets on qualifying expenses until you drop below the asset limit. Once you drop below the asset limit, the Medicaid system will cover your costs. Assets are separated into two categories: countable and non-countable. Countable assets count towards the asset limit of $2,000. Some examples of a countable asset may include cash, your bank accounts, and stocks. Non-countable assets do not count towards the asset limit of $2,000. Some examples of a non-countable asset may include a first automobile, money prepaid for funeral expenses, or a primary residence if a spouse still resides in that home. One of the methods in pre-planning for Medicaid is to strategically turn your countable assets to non-countable assets. Doing this will help preserve the value of your assets, while dropping you below the asset limit, qualifying you for Medicaid benefits. We work with you to find the best methods and options of converting assets to non-countable assets to preserve the most value for you and fit your specific needs. Contact one of our attorneys at our Wisconsin, Minnesota, or California locations to make sure your assets are properly protected. And for more information on wills, trusts, life estates, Medicaid planning, and estate planning. In this video, we will discuss the top benefits of having a will. Creating a will is an essential step in ensuring that your wishes are respected and your loved ones are taken care of after you're gone. It is a critical part of estate planning that can save your family from unnecessary stress and conflict. Having a will provides peace of mind, knowing that your wishes will be followed after you're gone. For instance, imagine a family where the primary breadwinner passes away without a will. The family might face legal hurdles and financial uncertainties, adding to their grief. A will can prevent such scenarios by clearly outlining your wishes. A will helps avoid family disputes. Without a will, disagreements about asset distribution can lead to lasting rifts in family relationships. When your intentions are clearly outlined, there's less room for misunderstandings and disagreements among family members, ensuring a smoother transition during a difficult time. By having a will, you maintain control over the distribution of your assets. You decide who gets what and how much, making sure that your belongings, whether they are properties, family heirlooms, or financial assets, go exactly where you want them to go. This prevents the state from making these decisions for you. If you have minor children, a will is crucial for naming a guardian. This ensures that someone you trust will take care of your children, rather than leaving the decision to the courts. The emotional and legal security provided by naming a guardian cannot be overstated. A will can also speed up the probate process. Probate is the legal process of distributing your assets after death. By clearly stating your wishes, you help streamline the legal proceedings, reducing the time and cost associated with probate. This can significantly ease the burden on your loved ones during an already difficult time. Including charitable contributions in your will is another benefit. You can leave a legacy by donating to causes that matter to you, making a positive impact even after you're gone. In summary, having a will provides peace of mind, helps avoid family disputes, allows you to control asset distribution, ensures guardianship for minor children, speeds up the probate process, and enables charitable contributions.
Your home is paid off. Your retirement accounts are healthy. You're living the American dream. Then it happens. A stroke. A fall. Alzheimer's creeping in like fog over a harbor. Suddenly, you need round-the-clock care and the bill. Try $120,000 a year, every single year. That's $10,000 a month disappearing from everything you've built. Within 3 years, your life savings are gone. Your spouse is left scrambling, potentially facing poverty after a lifetime of financial responsibility. Your children watch helplessly as their inheritance, meant to secure their own retirements, evaporates into the healthcare system. This isn't a nightmare scenario. This is Tuesday afternoon in America for thousands of families. The truth is, nursing home costs aren't just expensive. They're catastrophic. We're talking about an industry that has turned elder care into a wealth extraction machine. And here's the kicker. Medicare covers almost nothing. Medicaid will help, but only after you've spent down nearly every asset you own. You're essentially required to become impoverished before the safety net kicks in. But what if I told you there are completely legal strategies that savvy families use to protect their assets while still qualifying for benefits? What if there were ways to ensure your spouse doesn't end up destitute, and your children aren't forced to choose between their own financial security and your care? Today, I'm going to walk you through the exact methods that estate planning attorneys use for their own families. The strategies that the wealthy have been quietly employing for decades while middle-class America gets financially decimated by long-term care costs. We'll explore everything from the 5-year look-back period to sophisticated trust structures that can shield millions in assets. This isn't about gaming the system or committing fraud. These are legitimate, court-tested strategies that Congress specifically allows because they recognize that impoverishing families shouldn't be the price of growing old in America. Let's start with the brutal mathematics of nursing home costs, because understanding the scope of this threat is crucial to appreciating why asset protection isn't just smart, it's essential. The average cost of a private room in a nursing home has skyrocketed to over $120,000 annually. In high-cost areas like New York or California, you're looking at $150,000 to $200,000 per year. That's more than most people's entire annual income, and it's due every month regardless of the quality of care. Memory care facilities, which many Alzheimer's patients require, can cost even more. We're talking $180,000 to $250,000 annually for specialized dementia care. And here's what really stings. The average nursing home stay is 2.4 years, but that's just an average. 20% of residents stay 5 years or longer. Some families face a decade or more of these crushing expenses. Do the math. Even at the national average, a 3-year stay costs $360,000. A 5-year stay? $600,000. These numbers aren't theoretical. They're the financial reality facing 1.3 million Americans currently living in nursing homes, with 10,000 baby boomers turning 65 every single day. Medicare, the program most people assume will cover their long-term care, provides virtually no help. It covers skilled nursing care for a maximum of 100 days, and only if you meet strict criteria about being hospitalized first and requiring skilled medical care, not just custodial care. Most nursing home residents need custodial care, help with bathing, dressing, eating, basic daily activities. Medicare doesn't cover that at all. So families face a choice. Pay out of pocket until you're broke, or spend down your assets to qualify for Medicaid. This spend-down process is where most families make critical mistakes that cost them hundreds of thousands of dollars unnecessarily. Medicaid will cover nursing home costs, but there's a catch. You can only keep $2,000 in countable assets. Your house might be protected while you're alive, but Medicaid has the right to recover costs from your estate after death. Your retirement accounts, your savings, your investments, all of it must be liquidated to pay for care before Medicaid steps in. For married couples, the rules are slightly more generous, but still devastating. The community spouse, the one still living at home, can keep approximately $150,000 in assets and monthly income of around $3,800. Everything above those limits must be spent on the nursing home spouse's care. Imagine working for 40 years, building a $800,000 nest egg, only to watch $650,000 of it disappear into nursing home payments. But here's where it gets interesting. Medicaid has what's called a 5-year look-back period. Any gifts or asset transfers made within 5 years of applying for benefits are scrutinized. Make an improper transfer, and you face a penalty period where you're ineligible for benefits. This is where most families panic and make expensive mistakes. However, and this is crucial, there are numerous exceptions and strategies that allow for proper asset protection even within this look-back period. The key is understanding what Medicaid considers a legitimate transfer versus what triggers penalties. Transfers to certain types of trusts, purchases of exempt assets, and specific gifting strategies can all be done legally and effectively. The wealthy figured this out long ago. They don't lose sleep over nursing home costs because their estate planning attorneys have structured their assets properly. They use irrevocable trusts, strategic gifting programs, and asset repositioning techniques that keep their wealth protected while still qualifying for benefits when needed. The middle class, meanwhile, typically gets advice that sounds something like this. Well, that's not advice. That's surrender. And it's completely unnecessary if you understand the rules and plan accordingly. What we're about to explore are the specific strategies that can protect your assets legally and ethically. From simple techniques that anyone can implement to sophisticated trust structures for larger estates, there are options available at every wealth level. The key is understanding the rules, timing your moves correctly, and avoiding the common pitfalls that trap unprepared families. Because here's the truth they don't want you to know. Asset protection from nursing home costs isn't about being wealthy. It's about being informed. The first and most accessible strategy in your asset protection toolkit is understanding exempt assets. These are resources that Medicaid simply cannot touch, regardless of their value. Your primary residence is an example of an exempt asset, protected in most states. But here's what most people don't realize. You can actually increase this protection by making strategic home improvements or paying down your mortgage with countable assets. Think about it. If you have $100,000 sitting in a savings account, that's a countable asset that must be spent down. But if you use that same money to renovate your kitchen, add a bathroom, or install a new roof, you've just converted countable assets into exempt assets. The value is still there, it's just protected now. This isn't hiding money. This is smart repositioning. Your car is another exempt asset, but only one vehicle per household. Families have legitimately purchased $80,000 luxury vehicles or specially equipped vans and had them considered exempt assets. Again, you're not losing the value. You're converting it into a protected form. However, after you pass away, Medicaid will attempt to recover assets from your estate for any expense they paid on your behalf. This means they may be able to recover your house or car. To solve this, let's move beyond basic exempt assets and talk about more sophisticated strategies. The irrevocable trust is perhaps the most powerful tool in the asset protection arsenal. When properly structured, these trusts can protect unlimited assets from nursing home costs while still providing some benefits to the person who created them. Here's how it works. You transfer assets into an irrevocable trust, typically naming your children or other beneficiaries as the ultimate recipients. The trust is structured so that you retain certain limited rights, perhaps the right to live in your home if it's transferred to the trust, or the right to receive income from investments held by the trust. The key is that you no longer own these assets outright, so they're not counted for Medicaid purposes. The catch? This strategy requires advanced planning. Remember that 5-year look-back period. Any assets transferred to an irrevocable trust must be done at least 5 years before applying for Medicaid benefits. That's why this isn't a crisis planning technique. It's a long-term strategy that requires foresight and commitment. But what if you're already facing an immediate need for long-term care? What if that 5-year window is closed? Don't despair. There are still powerful strategies available, though they require more sophisticated planning and often professional guidance. The Medicaid-compliant annuity is one such technique. By converting countable assets into an income stream through a specially structured annuity, you can often protect significant wealth while still qualifying for benefits. The annuity must meet specific requirements. It must be immediate, irrevocable, and actuarially sound. But when done correctly, It can preserve hundreds of thousands of dollars. For married couples, the strategies become even more nuanced and powerful. The Community Spouse Resource Allowance allows the at-home spouse to retain approximately $150,000 in assets. But through a technique called spousal refusal, the community spouse can actually refuse to contribute their assets to the nursing home spouse's care. This creates a fascinating dynamic where the nursing home spouse can qualify for Medicaid while the community spouse retains significantly more assets. Asset purchase strategies offer another avenue for protection. Instead of simply spending down assets on nursing home care, families can purchase items that are either exempt or provide ongoing value. Prepaying funeral expenses, buying a more expensive home in a state with higher homestead exemptions, or purchasing certain types of life insurance can all serve as effective spend-down strategies that preserve value for the family. The key to all of these strategies is understanding that Medicaid planning isn't about impoverishment. It's about reorganization. You're not making assets disappear. You're restructuring them in ways that comply with Medicaid rules while still providing maximum benefit to your family. Geographic arbitrage plays a role too. Some states are far more generous in their Medicaid rules than others. The homestead exemption varies dramatically by state. Income and asset limits differ. Even the rules around trust protection vary significantly. Families sometimes relocate strategically to take advantage of more favorable Medicaid rules in their new state of residence. But perhaps the most overlooked strategy is the proper use of caregiver agreements. When adult children provide care for aging parents, this care has real economic value. A properly structured caregiver agreement allows families to compensate adult children for this care, effectively transferring assets while receiving legitimate services in return. The key is documenting the arrangement properly and ensuring the compensation is reasonable for the services provided. Finally, these strategies can often be used together to create a plan that works for your situation. The mistake most families make is waiting until crisis hits before exploring these options. By then, many of the most powerful strategies are no longer available. The 5-year look-back period means that effective asset protection requires the kind of advanced planning that most people resist because it forces them to confront uncomfortable realities about aging and long-term care. While you can still protect a portion of your assets if there was no plan when a crisis hit, planning ahead at least 5 years gives you the biggest opportunity to protect the most amount of assets. This is where the wealthy have always had an advantage. They plan early, they plan comprehensively, and they work with professionals who understand these complex rules. But these strategies aren't reserved for the ultra-rich. Middle-class families can implement many of these same techniques with proper guidance and sufficient lead time. The question isn't whether you'll face long-term care costs. The statistics are clear. Most of us will need some form of extended care before we die. The question is whether you'll face those costs with a plan that protects your family's financial security, or whether you'll join the millions of Americans who watch their life savings disappear into the healthcare system. So there you have it. The roadmap that separates families who preserve their wealth from those who watch it vanish into the nursing home abyss. From exempt asset strategies and irrevocable trusts to caregiver agreements and geographic planning, these aren't just theoretical concepts. They're the actual tools that informed families use to navigate the brutal mathematics of long-term care without sacrificing everything they've built. Remember, this isn't about gaming the system. It's about understanding rules that were specifically designed to prevent the complete impoverishment of American families. The wealthy have been using these strategies for decades, while middle-class America gets steamrolled by costs they never saw coming. The clock is ticking on your planning window. Every day you wait is another day closer to that 5-year look-back period that could lock you out of your best options. Don't be the family that discovers these strategies exist only after it's too late to implement them. Your life savings don't have to become a casualty of growing old in America. With proper planning, the right strategies, and sufficient lead time, you can protect what you've built while still ensuring quality care when you need it. The choice is yours, but the time to make it is now. Thanks for joining me today. If this opened your eyes to possibilities you didn't know existed, Share it with someone who needs to hear this message. Because in the end, financial security in retirement isn't about luck. It's about knowledge, and knowledge shared is power multiplied.
Today, we're going to talk about a topic that many might overlook: funeral trusts. A funeral trust is a legal arrangement you set up in advance to cover your funeral expenses. It ensures that the money you set aside will be used specifically for your funeral costs, alleviating financial and emotional stress for your family during a difficult time. A funeral trust is a financial arrangement in which funds are set aside to pay for your future funeral and burial expenses. This trust can be revocable, meaning you can change or cancel it, or irrevocable, meaning once it's set up, it can't be altered or revoked. So why consider a funeral trust? Here are a few key benefits. Number 1. Financial protection. Funeral trusts can help protect your assets from being used for other purposes. This is especially important for individuals seeking to qualify for Medicaid, as funds in an irrevocable funeral trust are typically exempt from asset limits. Number 2. Peace of mind. Knowing that your funeral expenses are covered provides peace of mind for both you and your loved ones. It's one less thing for your family to worry about during a time of grief. Number 3. Cost control. By setting up a funeral trust, you can lock in current prices for funeral services, protecting you from inflation and rising costs over time. Now, let's talk about how to set up a funeral trust. There are a few key steps to follow. First, consult with a professional. Work with a qualified attorney or financial advisor to understand your options and ensure the trust is set up correctly. Next, choose a funeral provider. Select a funeral home or provider and decide on the services you want. This could include everything from burial or cremation to specific types of services and merchandise. Then, fund the trust. Transfer the funds into the trust. The amount you deposit will depend on the estimated cost of your chosen funeral services. Before setting up a funeral trust, here are a few important considerations. Firstly, decide whether a revocable or irrevocable trust is best for your situation. Each has its advantages and limitations. Secondly, understand that funeral trust laws vary by state, so it's crucial to be aware of the regulations in your area. Finally, choose a reliable trustee who will manage the funds and ensure they are used appropriately when the time comes. While it's a difficult topic to think about, setting up a funeral trust is a thoughtful and practical step that can provide significant benefits. It's about planning ahead and making sure your final wishes are honored without placing a financial burden on your loved ones. Thank you for watching. If you have more questions or need guidance on setting up a funeral trust, consult with a qualified attorney to explore your options. Welcome to our series on estate planning. Today, we're going to discuss digital estate planning and how to manage your digital assets and online accounts in your estate plan. In our digital age, it's crucial to include these assets in your planning. First, what are digital assets? Digital assets include anything stored electronically, such as email accounts, social media profiles, online banking, digital currencies, and more. These assets fall into several categories: personal, financial, social media, and business-related. To begin, identify your digital assets. Create an inventory listing all your digital assets along with usernames, passwords, and security questions. This inventory will be essential for your executor or beneficiaries to access and manage these assets after you're gone. Legal considerations are also important. The legal framework surrounding digital assets can be complex. Laws such as the Revised Uniform Fiduciary Access to Digital Assets Act, RUFADAA, help govern how digital assets are handled after death. Understanding these laws will help you create a more effective digital estate plan. Access and control are crucial elements. Ensure your executor or beneficiaries can access your digital assets. Use password managers and secure storage solutions to store your login information. This makes it easier for your trusted individuals to access your accounts when needed. Include specific instructions for handling your digital assets in your estate plan. For social media accounts, you may want to specify whether they should be memorialized or deleted. For email accounts, provide clear instructions on how to manage or close them. For online banking and digital currencies, outline how these assets should be transferred or accessed. Appointing a digital executor is another key step. A digital executor is responsible for managing your digital assets according to your wishes. Choose someone tech-savvy and trustworthy. Clearly outline their responsibilities and the extent of their authority in your estate plan. Regularly update your digital estate plan. Review and update your digital asset inventory to reflect new accounts, changes in passwords, and other updates. This ensures your plan remains current and effective. Protecting privacy and security is paramount. Take steps to protect your digital assets against identity theft and data breaches. Use strong, unique passwords, enable two-factor authentication, and store your inventory in a secure location. Communication is essential. Inform your executor and beneficiaries about your digital estate plan. Provide them with access instructions and necessary documentation to ensure they can manage your digital assets effectively. Let's look at a real-life example. Imagine someone who has significant online assets, including a blog generating income, multiple social media accounts, and digital currencies. By creating a digital estate plan, they ensure their digital executor can access these assets, manage them according to their wishes, and distribute any financial benefits to their beneficiaries. In summary, digital estate planning involves identifying your digital assets, providing access and control, including specific instructions in your estate plan, appointing a digital executor, regularly updating your plan, and protecting privacy and security. By including digital assets in your estate plan, you can ensure a smooth transition and protect your digital legacy. Thank you for watching. If you have any questions or need personalized advice, consult with a qualified estate planning attorney. See you in the next video.
You may ask, why should I avoid probate? The answer is simple: time and money. The probate process can be cumbersome and take significant time and money. However, the probate process can be avoided. Trusts, when properly set up and funded, can avoid probate. The question is, does a will avoid probate? No. Assets controlled by a will do not avoid probate. A will by its nature directs the assets through the probate process for administration and ultimate distribution to the beneficiaries. There are a number of ways to avoid probate. First, you can give away all your money and assets, so you have nothing to pass along. Second, you can add a joint owner to your assets or add a payable or transfer on death designee to your accounts. Third, you can establish a life estate on your property. Finally, you can avoid probate with a trust. Adding a joint owner or adding a payable or transfer on death designee is a simple solution. However, they do not offer the same benefits as a trust. Adding a joint owner or adding a payable on death or transfer on death designee does not offer asset protection for beneficiaries, can potentially cause a loss of government benefits for a beneficiary with a disability or special needs, and does not help with potential future incapacity. With a life estate, you do not own entire interest in the property. The interest in the property is split into two pieces: the current interest and the interest the other owner, the remainderman, has after your passing. Additionally, if you wish to sell the property, you can only sell the portion you own, your life estate, and you would need permission from the remainderman to sell the entire interest. A properly set up and funded trust can solve these issues. A trust can give possible asset protection for beneficiaries. With a trust, you can retain control of assets. A trust has the ability to protect beneficiaries with disabilities or special needs. Finally, a trust can plan for incapacity. The only downside of a trust is the initial setup. To ensure your will or trust is set up properly, contact Heritage Law Office today.
For less than the cost of 1 month in a nursing home, this strategy can protect your entire life savings. The cost of nursing home care can be overwhelming, often exceeding $9,000 per month. Medicaid rules require that your assets fall below a certain limit before you can qualify for free nursing home care. This asset limit is often shockingly low, $2,000 in many states. This means you'll have to deplete your entire life savings before you can receive assistance. However, there is a solution: an irrevocable trust. By creating an irrevocable trust and transferring your assets into that trust, you can set aside and protect assets and qualify for Medicaid. When you transfer your assets into an irrevocable trust, the assets are no longer considered yours. The trust owns the assets. This means if you transfer your assets into this trust and you fall within the Medicaid eligibility limits, you can qualify for Medicaid without spending down your life savings. By using this strategy, you can qualify for free nursing home care while your assets in the irrevocable trust are protected and set aside for your loved ones. However, it's important to note the 5-year look-back period. Medicaid reviews your financial transactions for the past 5 years, and any transfers made during this period could result in an ineligibility period. Assets transferred longer than 5 years ago do not affect your eligibility. If you expect to require nursing home care within 5 years, you can still benefit from this type of estate planning, but the results are much more limited than if you planned at least 5 years ahead. Therefore, planning ahead is crucial. Start planning today to protect your hard-earned assets.
So you want to put your home into a trust? It's easier than you think. Here's how to do it in 3 steps. Step 1. Gather all your property documents and trust paperwork. You need to know what you're working with before you start. Step 2. Choose the right type of trust for your needs. Revocable, irrevocable. Pick what suits you best. Final step. Transfer the title of your home into the trust. Just like that, your home is protected and secure. Want more? Follow for more estate planning videos.
When you pass away, your debts do not expire with you. Most debt still needs to be paid off, if possible, although who is responsible for paying the debt depends on the type of debt, and some assets are protected from being used to satisfy a debt. Outstanding debt may include mortgages, credit card bills, car loans, personal loans, or condominium fees. Usually, your estate is responsible for paying any debts you leave behind. If the estate does not have enough money, the debts will go unpaid. In general, debt collectors may not try to collect payment from your relatives and heirs. However, there are some exceptions. Co-signers and guarantors of a particular debt are responsible for that debt, and someone who held property jointly with you would be responsible for any debts on the joint property. In addition, spouses in community property states may be responsible for some debt. Creditors are paid from the part of your estate that passes through probate, which means any property that passes through a will. The person who is appointed personal representative or executor of your estate is responsible for making sure the creditors are paid. The personal representative uses estate assets to pay off the debts before any money passes to heirs. If you have significant debts, it is possible that your entire estate will be used to pay creditors. Creditors cannot be paid from any assets that pass directly to a beneficiary. For example, a jointly held bank account would pass directly to the joint owner, and the funds in that account could not be used to pay creditors. Similarly, life insurance policies pass directly to the beneficiaries, so creditors do not have access to those funds. Whether or not a creditor can access funds in a trust depends on state law as well as what kind of trust it is. Contact Heritage Law Office to make sure your assets are protected.
If something happened tomorrow, would your family know what to do? In this video, I'll guide you through a simple estate planning roadmap. Let's take a look at the phases of estate planning. First, set your goals. Next, create an inventory of your assets. Then, choose your fiduciaries, draft the necessary documents, fund and organize your estate, and finally, review your planning. Step 1. Define your goals. This is crucial as it shapes your entire plan. Think about who you want to benefit and how you want your assets distributed. Step 2. Inventory your assets. Knowing what you have helps in making informed decisions about your estate plan. This includes everything from property to bank accounts. Step 3. Choose your fiduciaries. These are the people you trust to carry out your wishes, like executors or trustees. Choose wisely. Step 4. Draft your documents. This typically includes a will, a revocable living trust, and powers of attorney. Each document serves a specific purpose in your plan. Step 5. Fund and organize your estate. This means ensuring your assets are properly titled and beneficiaries are designated. Don't let your trust go unfunded. Step 6. Review your plan regularly. Life changes, and so should your estate plan. Make it a habit to check in every few years or after major life events. Now let's talk about costs and timelines. DIY kits can be affordable, but hiring an attorney can provide peace of mind. Expect to spend anywhere from a few hundred to several $1,000s, depending on complexity. Typically, the process from consultation to signing can take 2 to 6 weeks. Remember, funding your trust is an ongoing task that requires attention. To wrap up, remember these 3 key takeaways. Plan, fund, and review your estate plan regularly. It's essential for your peace of mind.
In this video, we will discuss how to set up a land trust, its benefits, and how it can protect your assets. What is a land trust? A land trust is a legal entity that allows you to manage and control real estate assets while keeping your ownership private. This can be particularly useful for safeguarding your assets from creditors, lawsuits, and other potential risks. With a land trust, you create a private agreement where a trustee holds the title to a property for the benefit of one or more beneficiaries. The main advantage of a land trust is that it allows the beneficiaries to retain control over the property while keeping their identities confidential. Key features of a land trust include privacy, control, and flexibility. The names of the beneficiaries are not disclosed in public records. Beneficiaries maintain control over the property, and they can transfer their interest in the trust without public record changes. What are the benefits of land trusts? People often choose a land trust is the privacy it offers. Since the trustee holds the title, the names of the beneficiaries are not listed in public records, making it difficult for potential litigants to identify the true owners. Additionally, by placing property in a land trust, it becomes more challenging for creditors to seize your assets. Creditors may find it difficult to discover the existence of the trust or determine the property's value, deterring legal actions and settlement negotiations. Land trusts also simplify the process of transferring property ownership. Beneficiaries can transfer their interest in the trust without triggering a public record, useful for estate planning and avoiding probate. How does a land trust work? To establish a land trust, you need to create a trust agreement that outlines the terms and conditions. This document identifies the trustee, beneficiaries, and the powers and responsibilities of each party. An experienced attorney should draft the trust agreement to ensure compliance with state laws. The trustee holds the legal title to the property and manages it according to the trust agreement, while beneficiaries retain control and direct the trustee on property management actions. While land trusts offer numerous benefits, they also have potential drawbacks. They provide limited asset protection compared to other entities like LLCs or irrevocable trusts. Setting up and maintaining a land trust can be complex and may require ongoing legal assistance. Additionally, there may be tax implications, so consulting a tax professional is essential. Integrating land trusts with other strategies. To maximize asset protection, consider integrating land trusts with other legal entities like LLCs, which combine privacy with liability protection. Irrevocable trusts and Medicaid asset protection trusts can also enhance asset protection. Common uses of land trust. Land trusts are popular among real estate investors for anonymous purchases, streamlined transactions, and avoiding due-on-sale clauses. They are also valuable for estate planning, asset management for high-net-worth individuals, and charitable giving. To create a land trust, consult with an experienced attorney, select a reliable trustee, draft the trust agreement, transfer the property title, and maintain the trust. Thank you for watching the video. If you found it helpful, please like and subscribe.
Thinking about how to protect your assets and make life easier for your loved ones? A revocable trust might be the answer. A revocable trust lets you transfer ownership of your assets, like your home and bank accounts, into a trust while keeping full control. You can buy, sell, or move assets in and out of the trust just like always. And since it's revocable,
You can change or cancel it anytime you want. One major benefit? Avoiding probate. It's the court process that can be time-consuming and expensive when someone dies with just a will. With a revocable trust, your assets pass directly to your beneficiaries, meaning less hassle and more privacy for your loved ones. Plus, if you become incapacitated, you can name a successor trustee to manage your affairs, avoiding confusion and family conflict.
Welcome to our series on starting a business. Today, we're going to discuss the key legal steps you need to take when starting a new business. Understanding these legal considerations is crucial for ensuring your business operates smoothly and is set up for success. First, let's talk about choosing the right business structure. The most common structures are sole proprietorship, partnership, limited liability company, or LLC, and corporation. Each structure has different implications for liability, taxes, and management. A sole proprietorship is the simplest form but doesn't provide personal liability protection. An LLC offers liability protection and flexible tax options, making it a popular choice for small businesses. Corporations provide the most liability protection but come with more regulatory requirements. Next, you need to register your business. This involves choosing and registering your business name, often called a DBA, or doing business as. You'll need to file the necessary paperwork with your state and local authorities. Obtaining the necessary licenses and permits is another key step. The requirements vary depending on your business type and location. For example, a restaurant may need health permits, while a construction company may need specific contractor licenses. Research the licenses and permits required for your business and apply for them before you start operating. Understanding your tax obligations is essential. Start by obtaining an Employer Identification Number, or EIN, from the IRS. This number is used for tax filings and other business activities. You should also understand your obligations for sales tax, payroll tax, and income tax. Consulting with a tax advisor can help ensure you meet all your tax responsibilities. Creating a business plan is both a strategic tool and a legal consideration. A comprehensive business plan includes an executive summary, market analysis, and financial projections. It helps guide your business decisions and can be crucial for securing financing. Setting up your business finances is important. Open a business bank account to keep your personal and business finances separate. Set up accounting and bookkeeping systems to track your income and expenses accurately. Understanding your business insurance options is also important. Insurance can protect your business from various risks, such as liability claims and property damage. Employment law considerations are crucial if you plan to hire employees. Understand the difference between hiring employees and independent contractors. Comply with employment laws regarding wages, benefits, and workplace safety. Creating employment contracts and an employee handbook can help outline expectations and legal requirements. Protecting your intellectual property is vital. This includes trademarks, copyrights, and patents. Register your intellectual property to prevent others from using your brand or products without permission. Drafting key contracts and agreements is essential for legally binding business relationships. This includes partnership agreements, client contracts, and supplier agreements. Having clear, written agreements helps prevent disputes and outlines each party's responsibilities. Compliance with industry regulations is critical. Each industry has specific regulations that businesses must follow. Ensure you understand and comply with these regulations to avoid legal issues. Seeking professional advice is highly recommended. Consulting with legal, financial, and business advisors can help ensure you're taking the right steps. In conclusion, starting a business involves several key legal steps: choosing the right business structure, registering your business, obtaining necessary licenses, understanding tax obligations, creating a business plan, setting up finances, complying with employment laws, protecting intellectual property, drafting key contracts, and ensuring industry compliance. Taking these steps will help you build a solid legal foundation for your business. Thank you for watching. If you have any questions or need personalized advice, consult with a qualified attorney or business advisor. See you.
Most families think they've got their estate planning sorted out when they write a will. But here's the harsh reality. They're setting their loved ones up for months of legal headaches, thousands in unnecessary fees, and family drama that could tear relationships apart forever. I've seen it happen countless times, And today, I'm going to show you exactly why the choice between a will and a trust could be the difference between leaving your family a gift or leaving them a nightmare. Look, I get it. When most people think about estate planning, they immediately jump to wills because that's what everyone talks about. Your parents probably had a will, your grandparents had a will, and every movie you've ever watched shows some dramatic will reading scene. But here's what nobody tells you. Wills are actually one of the worst ways to transfer wealth to your family. Now, before you think I'm completely crazy, let me explain exactly what I mean. I'm going to break down the real differences between wills and trusts in a way that actually makes sense, without all the legal jargon that usually makes your eyes glaze over. By the end of this video, you'll understand why most wealthy families use trusts, and more importantly, how you can protect your family the same way. But first, let me share a story that perfectly illustrates why this matters so much. Meet a woman named Sarah. Her dad had passed away suddenly, leaving behind a house, some investments, and what everyone thought was a simple will. Sarah assumed everything would be straightforward. After all, her father had been organized, he'd written everything down clearly, and the will seemed to cover all the basics. But what happened next was a complete disaster. The will had to go through probate court, which meant every single asset became public record. Suddenly, distant relatives she hadn't spoken to in years started coming out of the woodwork, claiming they deserved a piece of the inheritance. The legal fees started piling up. First, it was a few $100s here and there. Then, it became thousands. The house couldn't be sold because it was tied up in probate. The investment accounts were frozen. And Sarah found herself spending every weekend dealing with lawyers, court filings, and family members who were suddenly very interested in her father's money. 18 months and $23,000 in legal fees later, Sarah finally received what should have been hers from the beginning. But by then, the stress had taken its toll. Her relationship with her brother had completely fallen apart over disagreements about the estate. Her mother was devastated by all the family conflict. Sarah wouldn't wish that experience on her worst enemy. The crazy part? All of this could have been completely avoided if her father had used a trust instead of a will. While Sarah was dealing with lawyers and court dates, families with trusts were quietly transferring assets to their loved ones without any of that drama. So, what exactly is the difference? And why does it matter so much? Most people think a will and a trust do the same thing, just with different paperwork. That's like saying a bicycle and a Ferrari both get you from point A to point B. Technically true, but you're missing the entire picture. Here's the thing that blows most people's minds. A will doesn't actually avoid probate court. In fact, having a will guarantees you'll go through probate. It's like having a roadmap that leads you straight into the most expensive, time-consuming legal process possible. When you die with a will, here's what actually happens. Your will becomes a public document that gets filed with the court. Every asset you own, every debt you owe, and every person who benefits from your estate becomes public information that anyone can access. Your nosy neighbor, that ex-business partner you had a falling out with, or even complete strangers can walk into the courthouse and read all about your family's private financial business. But that's just the beginning of the problems. Probate court moves at the speed of molasses on a cold day. We're talking months, often years, before your family can access the money and property you intended to leave them. During this entire time, your assets are basically frozen. Your family can't sell the house, can't access investment accounts, and can't make any major financial decisions without court approval. And let's talk about the costs, because this is where it gets really painful. Probate fees typically run between 3 and 7% of your total estate value. So, if you're leaving behind a $400,000 house and some investments, your family could be looking at $20,000 or more in fees before they see a single penny. That's money that should be going to your kids or grandkids, but instead it's padding some lawyer's bank account. Now, here's where trusts completely change the game. Think of a trust as a special container that holds your assets while you're alive and then seamlessly transfers them to your beneficiaries when you're gone. No court involvement, no public records, no waiting periods, and dramatically lower costs. When you create a trust, you're essentially creating a separate legal entity that owns your assets. You remain in complete control as the trustee while you're alive, so nothing changes in your day-to-day life. You can still buy, sell, and manage everything exactly like you always have. But when you pass away, a successor trustee you've chosen steps in and distributes everything according to your wishes, usually within a matter of weeks. Think about it this way. You wouldn't leave your family a gift wrapped in barbed wire, so why leave them an inheritance wrapped in legal red tape? The choice between a will and a trust isn't just about paperwork. It's about whether you want to leave your loved ones a blessing or a burden. Don't make the same mistake Sarah's father made. Your family deserves better than months of court battles and thousands in unnecessary fees when you could give them the gift of a smooth, private transfer that protects their relationships and their inheritance.
Welcome to our series on franchise law. Today, we're discussing the legal aspects of buying or starting a franchise. Understanding these aspects is crucial for making informed decisions and ensuring your business venture is successful. First, what is a franchise? A franchise is a business model where a franchisor grants a franchisee the right to operate a business using the franchisor's brand, products, and systems. The franchisee pays fees and agrees to operate the business according to the franchisor's guidelines. When considering a franchise, there are two primary legal documents you need to be familiar with: the Franchise Disclosure Document, or FDD, and the Franchise Agreement. The Franchise Disclosure Document, or FDD, provides detailed information about the franchisor and the franchise system. It includes the franchisor's history, litigation history, financial statements, initial and ongoing fees, and obligations of both parties. Reviewing the FDD thoroughly is essential. The franchise agreement is the binding contract between the franchisor and franchisee. It outlines the terms and conditions of the franchise relationship, including the rights and responsibilities of each party. Key terms to understand include the duration of the franchise, renewal terms, territorial rights, and conditions for termination. Conducting thorough due diligence is critical before buying a franchise. This involves reviewing the FDD, researching the franchisor's history and reputation, and understanding the financial commitments and projections. When buying a franchise, there are several legal considerations to keep in mind: initial franchise fees and ongoing royalties. Understand the total cost involved. Territorial rights and restrictions. Know your exclusive territory and any restrictions. Intellectual property rights. Understand your rights to use the franchisor's trademarks and proprietary systems. Obligations of the franchisor and franchisee. Clarify the support and training provided and expected. Renewal and termination clauses. Pay attention to the terms for renewing or terminating the agreement. Starting a franchise involves several key steps. Ensure legal compliance by registering your franchise and adhering to state-specific regulations. Develop an operations manual outlining how the franchise should be run. Protect your intellectual property by securing trademarks and trade secrets. Financial aspects are important. Explore financing options for buying or starting a franchise and understand the initial investment required, as well as ongoing expenses and royalties. Franchisee support and training are vital for success. Most franchisors provide initial training and ongoing support to help franchisees run their businesses effectively. Take full advantage of these resources. Disputes can arise in any business relationship. Common disputes in franchising include disagreements over territory, fees, and performance standards. Methods for resolving disputes include mediation, arbitration, and litigation. Address disputes promptly and seek legal advice if necessary. In conclusion, buying or starting a franchise involves navigating several legal aspects, from understanding the FDD and franchise agreement to conducting due diligence and ensuring legal compliance. Consulting with a qualified franchise attorney is essential to protect your interests and make informed decisions. Thank you for watching. If you have any questions or need personalized advice, consult with a qualified franchise attorney. See you in the next video.
An estate plan is a collection of legal documents and strategies that outline how your assets and affairs will be handled in the event of your death or incapacity. Key components of an estate plan include wills, trusts, powers of attorney, and healthcare directives. There are several compelling reasons to have an estate plan. First, it ensures that your wishes are followed regarding the distribution of your assets and care of your dependents. Second, it protects your assets from unnecessary taxes, expenses, and legal fees. Third, it provides for your family by outlining your intentions clearly, reducing stress and uncertainty for your loved ones. Without an estate plan, your estate may face significant legal complications and delays. This can lead to increased costs and taxes, reducing the inheritance you leave behind. Additionally, the absence of clear instructions can result in family disputes and conflicts over your estate. Starting an estate plan involves several key steps. Begin by taking inventory of your assets, including property, investments, and personal belongings. Decide on your beneficiaries and how you want your assets distributed. Next, consult with an experienced attorney to draft the necessary legal documents, such as a will or trust. Regularly review and update your estate plan to reflect changes in your life, such as marriage, divorce, or the birth of a child. An estate plan isn't just about distributing your assets. It also includes making decisions about your healthcare and financial affairs if you become incapacitated. Powers of attorney and healthcare directives allow you to appoint someone you trust to make decisions on your behalf, ensuring your wishes are respected. Having an estate plan is crucial for ensuring your wishes are respected and your family is protected. Don't wait until it's too late. Contact an attorney to start your estate plan today. This proactive step can provide peace of mind and security for you and your loved ones. Thank you for watching. Make sure to like and subscribe for more.
Life insurance is a powerful tool in estate planning. Life insurance is a contract between you and an insurance company. In exchange for regular premium payments, the insurance company pays a death benefit to your designated beneficiaries when you pass away. There are several types of life insurance, including term life, whole life, and universal life insurance. Life insurance can be a critical component of your estate plan, offering several key benefits. One of the primary benefits is providing liquidity. When you pass away, your estate may need immediate funds to cover various expenses, such as funeral costs, outstanding debts, and administration fees. Life insurance provides a source of immediate cash, which can help your family cover these expenses without having to sell assets or borrow money. Another significant use of life insurance is paying estate taxes. Depending on the size of your estate and the applicable laws, your estate may be subject to federal and state taxes. These taxes can be substantial and may need to be paid within a relatively short period after your death. Life insurance proceeds can be used to cover these tax liabilities, ensuring that your heirs receive their inheritance without having to liquidate assets to pay the taxes. Let's look at some specific ways life insurance can be used in estate planning. First, funding buy-sell agreements. If you own a business, a buy-sell agreement is a crucial part of your succession plan. This agreement outlines how a partner's share of the business will be handled if they pass away. Life insurance can fund these agreements by providing the necessary cash to buy out the deceased partner's share, ensuring a smooth transition and continuity of the business. Second, equalizing inheritances. If you have multiple heirs and not all of them are involved in the family business or other substantial assets, life insurance can provide a way to equalize inheritances. You can leave the business to the heirs who are involved and use life insurance proceeds to provide an equivalent value to the other heirs, ensuring that everyone is treated fairly. Third, covering final expenses. Life insurance can help cover the costs of your funeral, outstanding debts, and other final expenses. This relieves your family of the financial burden and allows them to focus on grieving and healing. Fourth, providing for minor children. Life insurance can ensure that your young dependents are financially secure. The proceeds can be used to cover their living expenses, education costs, and other needs until they reach adulthood. There are several benefits to using life insurance in estate planning. Life insurance proceeds are generally tax-free for the beneficiaries, providing a tax-efficient way to transfer wealth. Additionally, life insurance offers flexibility and control over the distribution of assets, allowing you to tailor your plan to meet your specific goals. Knowing that your loved ones will be taken care of can provide peace of mind. Setting up life insurance for estate planning involves careful consideration and planning. It's important to work with a qualified estate planning attorney and financial advisor to determine the right type and amount of coverage for your needs. They can help you choose the appropriate policy, designate beneficiaries correctly, and integrate life insurance into your overall estate plan. In summary, life insurance is a versatile and valuable tool in estate planning. It provides liquidity to cover immediate expenses, helps pay estate taxes, funds buy-sell agreements, equalizes inheritances, covers final expenses, and provides for minor children. By incorporating life insurance into your estate plan, you can ensure the financial security of your loved ones and the smooth transition of your assets. Thank you for watching. If you have any questions or need personalized advice, consult with a qualified estate planning attorney or financial advisor. See you in the next video.
You won't believe how many families lose thousands just because of simple estate planning mistakes. Here are the top 5 you need to avoid. Mistake number 1, not having a will at all. Over 60% of adults don't have one. If you die without it, the state decides who gets your stuff, not you. Mistake number 2, forgetting to update beneficiaries. Your ex-spouse could inherit your life insurance just because you forgot to update a name. Seriously, this happens all the time. Mistake number 3, thinking a will avoids probate. It doesn't. A will still goes through court. To avoid that, you need a trust. Mistake number 4, not planning for incapacity. Who handles your finances or makes medical decisions if you're in a coma? If you don't name someone, the court will. And mistake number 5, DIY estate plans. One wrong word or signature could make your whole plan invalid. Saving a few bucks now could cost your family everything later.
In this video, we'll explore how to choose the right executor for your estate, covering key considerations and steps to ensure your wishes are carried out. Choosing the right executor is a crucial part of estate planning. Your executor will manage your affairs, settle debts, and distribute your assets according to your will. Making an informed choice can provide peace of mind for you and your loved ones. An executor has several key responsibilities. They collect and manage assets, pay debts and taxes, and distribute assets to beneficiaries. They must act prudently, be impartial, and maintain detailed records. When choosing an executor, look for trustworthiness and integrity. Your executor should be someone you trust implicitly and who has a reputation for honesty. Financial acumen is also essential, especially if your estate includes complex assets. Organizational skills are crucial, as the executor must handle numerous documents and deadlines. They should also be able to handle stress and make sound decisions under pressure. Availability is another key factor, as the role can be time-consuming. Common choices for executors include family members, friends, and professionals. Family members and friends may have a personal interest in honoring your wishes, but it's important to consider their potential emotional strain and conflicts of interest. Professionals, such as lawyers or trust companies, offer expertise and impartiality but come with costs. Consider the size and complexity of your estate when choosing an executor. A large or complicated estate might benefit from a professional executor. Also, think about family dynamics and whether the person you choose can navigate potential conflicts. Geographical proximity can be beneficial, especially if your estate includes real property. Legal requirements vary by state, but generally, an executor must be of legal age, of sound mind, and free of felony convictions. Some states require executors to post a bond to protect the estate from potential mismanagement. You may also appoint co-executors to share responsibilities, but this can lead to conflicts if they disagree. Alternatives to traditional executors include corporate trustees, who provide professional management, and successor executors, who step in if your first choice is unable to serve. To formalize your choice, include your executor in your will, clearly stating their name and any specific instructions. Communicate your decision with your chosen executor and any successors, and review your will periodically to ensure it reflects any changes in circumstances. Avoid common mistakes, such as choosing an executor out of obligation, overlooking professional help, and ignoring potential conflicts of interest. Make a choice based on suitability for the role. Choosing the right executor requires careful consideration and foresight. To ensure your choice is legally sound and well-informed, consult with an experienced attorney. They can guide you through the process and help you select the best candidate for your needs. Thank you for watching. For more information on estate planning, be sure to subscribe to our channel and visit our website. In this video, we will discuss how to manage inherited property during probate, covering essential steps and common challenges you may face. Welcome to our channel. If you're dealing with the complexities of probate and inherited property, this video is for you. Let's dive into the key aspects of managing inherited property during probate. First, let's understand the probate process. Probate is the legal procedure of administering a deceased person's estate, ensuring debts are paid, and distributing the remaining assets to the rightful heirs. When handling inherited property, you'll need to locate and review the will, inventory the estate, notify creditors, settle debts, maintain the property, and decide on its future. One of the common challenges in handling inherited property is emotional attachment. Family disagreements can arise when heirs have differing opinions on what to do with the property. Sentimental value can also complicate decisions about selling or renting the property. Additionally, financial considerations like the costs of maintaining the property and potential tax implications need to be addressed. Legal complications, such as dealing with multiple heirs or unresolved debts, can also present challenges. If you decide to sell the inherited property, there are several steps to follow. First, prepare the property for sale by making necessary repairs and upgrades, and ensure it is clean and staged. Hiring a real estate agent experienced in estate sales is crucial. They can help you list the property, conduct a market analysis, and market it effectively to attract buyers. Finally, navigate the sale process by evaluating offers, negotiating terms, and finalizing the sale with the help of your agent and attorney. Here are some practical tips for handling inherited property efficiently. Stay organized by keeping meticulous records of all transactions and communications. Use digital tools and software to track important documents and deadlines. Seek professional advice from estate attorneys and financial advisors to navigate legal complexities and plan for tax implications. Communicate effectively with family members through regular meetings and open discussions. Lastly, be patient and compassionate, recognizing the emotional impact of losing a loved one and providing support to each other. In summary, managing inherited property during probate involves understanding the probate process, addressing common challenges, and following practical tips to navigate the complexities. If you need assistance, our knowledgeable attorneys are here to support you every step of the way. Contact us to ensure the probate process is as smooth as possible. Thank you for watching. If you found this video helpful, please like, share, and subscribe to our channel for more informative content.
Whether you're trying to avoid probate, protect your assets, or plan for your family's future, understanding trusts could save you thousands of dollars and months of headaches. But here's the thing most people get wrong about trusts. There are actually 3 simple steps to transfer your house into a trust, and we're going to break down each one so clearly that you'll wonder why you ever thought it was complicated. Plus, we'll reveal the one mistake that could completely invalidate your trust that many people make. First, you need to create the trust document itself. This isn't just filling out some random form online. The trust document establishes who controls the property, who benefits from it, and what happens when you're no longer around. You'll need to decide between a revocable living trust, which you can change anytime, or an irrevocable trust, which offers stronger asset protection but can't be modified easily. Next comes the actual property transfer. This means preparing a new deed that transfers ownership from your name to the trust's name. The deed must be properly notarized and recorded with your local county recorder's office. Without this step, your house never actually enters the trust, no matter what paperwork you've signed. Finally, you'll need to update all related documents and accounts. This includes homeowners' insurance policies, property tax records, and any existing mortgages. Many people forget this crucial step and end up with coverage gaps or compliance issues. The bottom line is this: transferring your house to a trust isn't rocket science, but it does require attention to detail and proper execution to protect what matters most. Most people think a will and a trust are basically the same thing, just different pieces of paper that do the same job. That couldn't be further from the truth. In fact, understanding the difference between these two could save your family thousands of dollars and months of legal headaches. I've seen families torn apart because they chose the wrong option, and I've also seen others sail through difficult times because they made the right choice. So today, I'm going to break down exactly how a will differs from a trust, when you should use each one, and which option might be right for your specific situation. By the end of this video, you'll have complete clarity on both options and know exactly which path makes sense for you and your family. But first, let me share something that might surprise you. According to recent studies, over 60% of Americans don't have either a will or a trust. That means most people are leaving their family's future completely up to chance. Don't be one of those people. Let's start with the basics. A will is essentially your final instructions. Think of it as a letter you're writing to the world, telling everyone exactly what you want to happen to your stuff after you're gone. It's straightforward, it's simple, and it only kicks into action after you pass away. You can name guardians for your children, specify who gets your house, your car, your savings account, and even your grandmother's antique jewelry. Here's the thing, though, and this is where most people get tripped up. A will has to go through something called probate court. That's basically a legal process where a judge makes sure everything in your will is legitimate and properly distributed. Sounds simple enough, right? Well, probate can take anywhere from 6 months to 2 years, and it's completely public. Anyone can walk into that courthouse and see exactly what you owned and who you left it to. A trust, on the other hand, is like having a personal financial manager that works even while you're alive. You can put your assets into a trust today, right now, and still control everything. You're essentially moving your stuff into this legal container, but you still get to use it however you want. The magic happens when you pass away. Everything in that trust goes directly to your beneficiaries without any court involvement whatsoever. Think about it this way. If a will is like leaving detailed instructions for someone to follow later, a trust is like having that someone already standing there, ready to act immediately. No waiting, no courts, no public records. Your family gets what you intended them to have, and they get it fast. But here's where it gets interesting. Trusts aren't just for wealthy people anymore. You might think you need millions to justify setting up a trust, but that's not true. If you own a home, have retirement accounts, or simply want to avoid the hassle and expense of probate, a trust could save your family significant time and money. The downside? Trusts are more complex to set up initially and typically cost more upfront. You'll need to actually transfer your assets into the trust, which means changing titles and beneficiary designations. It's not difficult, but it does require some paperwork. Wills, meanwhile, are simpler and cheaper to create, but they don't avoid probate and they don't help if you become incapacitated. With a trust, if something happens to you and you can't manage your affairs, your successor trustee can step in immediately. With just a will, your family might need to go to court to get permission to help you. The truth is, many people actually need both. A will can handle things that don't go into your trust, name guardians for minor children, and serve as a backup plan. A trust handles the bulk of your assets and provides privacy and efficiency. The bottom line is this: your choice between a will and a trust isn't just about legal documents. It's about how much control you want over the process, how quickly you want your family to receive their inheritance, and how much privacy matters to you. Choose wisely, because this decision will impact the people you care about most long after you're gone.
Titles and deeds play a pivotal role in legally recognizing and transferring property ownership. Join us as we break it down. What is a title? A title represents legal ownership of a property. It's the evidence that proves you have the right to possess, use, and control a piece of real estate. But what happens when you want to transfer that ownership? The importance of the deed. A deed is the legal document that conveys ownership from one party to another. Think of it as the passport for property, transferring the title and its associated rights. So, how does a typical transfer process look? Time to break it down. Understanding the transfer process. Step 1. Drafting the deed. A deed must include the grantor's and grantee's details, a description of the property, and the type of deed being executed. Step 2. Signature and notarization. The deed is signed by the grantor and often requires notarization for it to be legally valid. Step 3. Recording the deed. The signed deed is filed with the county's Land Records Office, ensuring it's public information and offers protection to the grantee. Deeds aren't all the same. There are different types based on specific situations. Warranty deed. This deed guarantees that the grantor owns the property and has the right to sell it. It provides the most protection for the buyer. Quitclaim deed. Used mainly between family members or in divorces, this deed transfers any ownership interest the grantor might have without any guarantees of that interest's extent. Special warranty deed. The grantor guarantees they haven't encumbered the property during their ownership, but makes no guarantees about previous owners. Navigating the landscape of property titles and deeds can be intricate, but with the right real estate lawyer by your side, the path becomes clearer. For more insights on real estate law, visit our website linked in the description. And remember, for regular legal wisdom, hit subscribe and tap that like button. A special needs trust is a type of trust that gives an individual with special needs access to funds in the trust without losing benefits provided by public assistance programs. Public assistance programs set up for people with special needs are generally predicated on income and asset limitations. The limitations may be surprisingly low in your state. However, money or assets that belong to the Special Needs Trust generally do not count toward the purpose of qualifying for public assistance. By properly setting up and funding a Special Needs Trust for the individual with special needs, they will have additional funds from the trust while still qualifying for public benefits. Improperly setting up or funding a special needs trust will generally result in loss of assets or loss of public benefits. Consult with a professional. All forms of trusts are important asset planning and protection tools that have their specific place. For more information on wills or trusts, contact a professional. In a life estate, two or more people each have an ownership interest in a property, but for different periods of time. The person holding the life estate, the life tenant, possesses the property during his or her life. The other owner, the remainderman, has a current ownership interest but cannot take possession until the death of the life estate holder. The life tenant has full control of the property during his or her lifetime and has the legal responsibility to maintain the property as well as the right to use it, rent it out, and make improvements to it. When the life tenant dies, the house will not go through probate, since at the life tenant's death the ownership will pass automatically to the holders of the remainder interest. Because the property is not included in the life tenant's probate estate, it can avoid Medicaid estate recovery in states that have not expanded the definition of estate recovery to include non-probate assets. Even if the state does place a lien on the property to recoup Medicaid costs, the lien will be for the value of the life estate, not the full value of the property. If the property is sold, the proceeds are divided up between the life tenant and the remaindermen. The shares are determined based on the life tenant's age at the time. The older the life tenant, the smaller his or her share, and the larger the share of the remaindermen. Be aware that transferring your property and retaining a life estate can trigger a Medicaid penalty period if you apply for Medicaid within 5 years of the transfer. Purchasing a life estate should not result in a transfer penalty if you buy a life estate in someone else's home, pay an appropriate amount for the property, and live in the house for more than a year. If you have any questions regarding life estates or estate planning, contact the experienced attorneys at Heritage Law Office for a free consultation. One way to pass a home to your child or children is to make a will and designate a beneficiary for your home in your newly created will. Although estate recovery issues need to be considered using this method, taxes can generally be reduced or eliminated as individuals receiving property upon the death of another are entitled to an adjustment in the cost basis, a step up when there are built-in gains. Gifting the family house to children has consequences that are often unforeseen by families looking to safeguard their assets. Making such a transfer puts you in a difficult position if your children go through divorce, bankruptcy, incur liability due to a lawsuit, or other financial problem occur that may require reselling the house. If you're planning to move out of the house now, you can give the property to your child. However, attorneys generally have better techniques than making such a transfer. A life estate allows you to transfer part ownership to your children, or anyone else, while you're alive. You can live in it, or rent it out, during your lifetime, and when you die, the remaining ownership passes to your kids or others to whom the asset was transferred, who may then take full possession and ownership of the assets. Placing the home in an irrevocable trust with your children as the beneficiaries is another option. Doing so may help you avoid estate taxes, qualify for Medicaid for nursing home or assisted living facility expenses, and protect the house from Medicaid estate recovery. Careful planning is a must, as making a transfer to an irrevocable trust may cause an ineligibility period for Medicaid for a period of time after such a transfer of your home. If the house is eventually sold, the proceeds remain in the trust, and the proceeds of the sale will be passed to the trust beneficiaries. If you gift a piece of real estate directly to your child or grandchild, it is perceived as a gift by the IRS. You cannot claim a loss, nor is your gift tax deductible.
Think a will is enough? Here's why a living trust might be the smarter move. First, living trusts avoid probate. Unlike a will, a living trust keeps your assets out of court. That means faster transfer to your loved ones and no costly probate fees. Second, living trusts provide privacy. Wills become public record, but trusts stay private. Your family matters, stay your family's business. Third, living trusts have flexibility. It's called living because you can change it any time while you're alive, update it as life changes. And fourth, living trusts provide continuity. If you become incapacitated, your trustee can step in immediately, with no court delays. Bottom line, a living trust saves time, money, and stress for your family. Want more estate planning information? Hit subscribe.
Think you're too young to need a will? If you're over 18 and have anything, like a bank account, car, or kids, it matters. Without a will, the law decides who gets what. And if you have children, the courts may choose who raises them. It might not be the person you'd want. Even a simple will gives you control over your assets and your wishes. It protects the people you care about, no matter your age or income. Waiting until you're older? That's one decision your family might pay for.
Gift tax? Most people get this completely wrong. Let me break it down with 2025 rules. The IRS lets you give someone up to $19,000 in 2025 without triggering gift tax. Sounds like a lot? You can do that for each person you gift. And if you're married and use gift splitting, you and your spouse can each give $19,000. That's $38,000 per recipient. No tax. What about bigger gifts? Here comes the lifetime exemption. In 2025, it's $13.99 million per person. That covers gifts plus your estate. That means if you exceed the annual $19,000, you probably still won't owe tax. You'll just use up part of your lifetime exemption. But you may need to file IRS Form 709 to report it. Smart strategies people use. Spread out gifts over years so you stay under the annual limit per person. Pay tuition or medical costs directly to the institution. Those are still fully exempt. Gift appreciating assets early, like stocks or real estate. So future growth happens outside your taxable estate. Heads up, starting January 1st, 2026,